All right. Good morning, everyone. Thank you so much for joining us. I am Cynthia Flynn, and of course, this is Tony Watson right here. I will turn it over to Tony to do his presentation, and then about 30 minutes from now, I'll be taking over and finishing it up. Feel free to ask questions throughout to both of us. You can do it, the best way to do it is through the Q&A. That way we can monitor them a little bit easier than in the chat. So with that being said, Tony, I'll turn it over to you and you can introduce yourself.
Great.
And screen share if you need to.
All right. So once again, my name is Tony Watson. I work for Robert Hall & Associates. We are a full-service tax consulting firm based out of Glendale, California. Once again, thank you so much for including us as part of this webinar. We're going to be talking a little bit about the tax implications in the, I don't know why it says real estate, actually. I think this probably was the one that I just gave this morning. But in general, how is the CARES Act going to be impacting individuals in the business world? Because obviously there's been a ton of changes over the past 2 or 3 months that a lot of people have questions about. In particular, the PPP plans and the EIDL plan and mortgage forbearance. And there's just a number of changes. And so our office phones have been ringing off the hook with a lot of concern, a lot of fear, and a lot of questions coming out of the fear and concerns about how is this going to impact them when they file next year for 2020's tax return, and obviously how to go about applying for all of the care packages that have been released as part of the CARES Act. So today we're going to talk a little bit about that, just to give you a little background of who I am and who I work for. I've been with Bob Hall now going on 15 years. I service roughly about 1,200 tax filings per year, anywhere from the small business owner tax filing making $30,000, $40,000 in gross revenue, all the way up to the full-blown C corporation return making $10 million in gross revenue. So I feel very fortunate to work for a firm where I get to see a lot of a lot. And make no mistake, this year has been quite the roller coaster ride, I'm sure, in all industries. I found that 15 years ago when I first started working for Bob Hall, I realized that everything kind of comes full circle to taxes, though. And so since 1971, he's actually been operating his firm. Like I said, 15 years ago, I came on board with Bob. And I've been able to help a lot of small business owners really take a stronghold of their taxes and figure out ways to reduce liability, grow their business, incorporate their business. And so I worked through the last recession, which was much different than the current situation that we're in right now. This has been an absolute whirlwind. And like I said earlier, there have been a lot of changes to the with the CARES Act, and obviously a lot of planning changes for individuals moving forward into 2020. But that's what we're here for. We're here to service the California communities as well as across the U.S. We do file taxes in all 50 states. So if there are questions at the end of the webinar, I'm sure we're going to have some time for Q&A. But if you don't want to ask specific questions, if you have more personal questions, then go ahead and feel free to reach out to our office and we can get those answers to you. Let's talk about some of the major changes. Actually, I put together this short list to show you what we are receiving as far as questions are concerned. These are the top 4 that we've essentially been handling over the past 2 months. Just to kind of get the first one out of the way, a lot of property owners and business owners who own the properties that they work out of have had questions about whether or not there's going to be mortgage relief involved in part of the CARES Act. And a lot of the banks have been working specifically with their clients to really find or figure out a plan for them to, obviously not move them out of the property. If you can't make your mortgage payment, why would they foreclose? Why would they short sell your property, right? So California's put a halt on all of that, but the banks are handling it in different ways. Some of the smaller banks are a little bit easier to deal with, but some of the larger banks are saying, hey, listen, we'll give you a 180-day extension to make your mortgage payment. And of course, as the client, you're thinking, okay, well, at the end of the 180 days, am I going to have to make a lump sum payment to pay off my mortgage that I haven't paid for the past half year? Or how is that going to work? Is the interest going to accrue? Or is that going to be added to the back part of my loan? And let's say that, because of the COVID-19 outbreak, let's say that at the end of the 180 days, I'm not able to pay my mortgage. Are there any more extensions? And so most banks have been allowed another 180 days on top of the first 180 days. So a little bit more than a full year, it looks like, or yeah, just around a full year, to not avoid paying your mortgage, but to delay mortgage payments. Right now, the best source of information for that would be your mortgage holder. So if it's a commercial building or if it's a residential building, you need to work with your lender to figure out a plan for you. And I'm sure that each bank has its own qualification process for mortgage forbearance. But this is a great way to free up some cash for you during these tough times as business owners, as employees of companies who are really hurting from this. First and foremost, reach out to your bank and see what kind of plan they have involved or implemented for you. I know that Chase and Bank of America and Wells Fargo, with specific clients of mine, they have already set forth the 180-day extension for paying mortgage. And what they are offering is either one, a refinance to wrap that into the back part of the loan and extend the loan term. And other banks have just said, hey, listen, we're going to give you 180 days to pay your mortgage. And at the end of the 180 days, if you have the ability to pay it as a lump sum, go ahead and do it. Otherwise, we'll set up a payment plan for whatever that amount is. But make no mistake, the interest on your loan debt still continues to accrue over this 180-day to 360-day period. So just keep that in mind. One of the major benefits, I believe at least, for individuals who are business owners, let's say that you're an employee, but then you have a spouse that might be self-employed. We need to make sure that you understand some of the major benefits built in for you as well. The federal government says, hey, listen, there's going to be a lot of people losing in this year, unfortunately, because of loss of revenue and still increased expenses. The government is actually allowing you to take losses from these years and actually carry them back to previous years. So keep that in mind. Those are some also major benefits. Talk with your tax advisor to figure out if this is an option for you. Some of the EIDL and the PPP loans that have come out, there's been a ton of questions surrounding EIDL and PPP. EIDL is probably one of the most common right now. PPP loans have been funded, and we've seen that money rolling in. EIDL loan, it essentially says that if you have a business and you have individuals that you pay as contractors or not, and employees as well, you can qualify for up to $1,000 per employee of a non-payback. So meaning that these loans are forgivable, and essentially it's free money for you to collect, once again, $1,000 per employee. And I believe it's up to $10,000. And this is something that you want to make sure that if you qualify for, that you do apply for. The PPP loan is a little bit different. The EIDL loan, it's a little bit easier to qualify for. The PPP loan, the Paycheck Protection Program, would be something that you would apply for, and you have to use that loan money for specific things. This is something that you absolutely want to work with your tax advisor on, or if you have a bank that's willing to fill out the application for you or assist with questions on that, the financial institutions, the SBA lenders are definitely a good source for information. Obviously, the point of these loans was to keep people employed, not to have them leave payroll and then all of a sudden be out of a job. But the PPP, if it's not used to keep individuals on payroll over the next 8-week period or 8 weeks from the date of the loan funded, and let's say that employees are let go, there are a couple options for you to qualify for unemployment insurance, obviously, as well as if you have some contract income. So I have some clients who are not only employees of businesses, but they also have little side businesses that they operate, or maybe even a spouse has a side business that they operate. There are options to file for PUA, which is the contractor unemployment insurance benefit. Now, this hasn't been around for very long. This actually just started, I think, 8 days ago on April 28th, where contractors, self-employed business owners, could actually apply for unemployment insurance as well. Understand that 2019's tax return is going to be a major tool in applying for all of these benefits. So if you haven't filed for 2019 yet, just make sure that you sit down with your tax advisor and make sure that you map out all of these numbers. And just so that you have an understanding of maybe 2018 wasn't a good year to use as applying numbers. And the bank is going to say, well, we either want 2019's figures or we want the past 12 months of income and expense figures to qualify for some of these benefits. The PUA and the UI, there were more people applying for unemployment insurance and PUA for over the past 8 days, but unemployment since this whole pandemic started. There have been more people applying for unemployment than ever in the history of the state of California, probably in the history of the United States. So just understand that a lot of what's going on right now requires some patience as well. We've been trying to deal with the IRS on a day-to-day basis, getting some answers to some questions that we have, and the IRS has actually stopped answering their phones. Or if you are willing to wait 3, 4, 5 hours on the phone, you might get somebody, but for the most part, the IRS is pretty much at the moment shut down. The state of California, same thing. You can call certain departments with the state of California, but a lot of it is just, just ringing, and you're not going to get an actual live person on the line. So just understand that a lot of what's going on right now with the COVID-19, with the coronavirus outbreak, you just have to remember to have patience with a lot of this. But there are these plans that are rolling out, and I believe that this is just the beginning, to be real honest with you. During the last recession in 2008, 9, 10, and 11, until we actually started to pull ourselves out of that recession, the federal government had implemented major changes years after the overall economic downturn. In 2010, the state of California enacted a relief plan for people who were losing their homes. It was called the Conformity Act of 2010, because the federal government had said, hey, listen, because of this pandemic, if you are at a significant loss where you can't afford to keep your home, and it did go into foreclosure or short sale, the federal government would actually allow you to walk away from the mortgage. And even though it was a cancellation of debt, even though you still owed the bank all of this money on the loan, that you as the taxpayer did not have to pay tax on the canceled debt. And so there are some insolvency rulings that you can file on your tax return. You don't necessarily have to be filing bankruptcy to get these benefits. So the reason why I'm giving you all of this information is just to make sure that you understand that there are professionals out there who are able to help you and guide you through these rough waters. Obviously, there are a lot of looming questions out there. People aren't getting the correct answers, or they're Googling their questions. And just like when, if you're feeling sick, you should never go to Google to diagnose your illness, right? You'll get 1,000 pop-ups and it'll tell you that, in one case that you might be dying, in the other case, it might just be a heat rash on your hand or something. You get these random things that you Google. For tax advice, it's the same thing. Don't Google your questions. Pick up the phone and call a licensed tax advisor and get the correct information so that you're not on this hamster wheel, right? Where you're just getting a bunch of misinformation and you're making bad moves because of having incorrect information. Obviously, there are some other scenarios where for employees, if you are thinking about applying for a refinance, or if you're going through the application for a home loan, I've had a couple questions saying, okay, well, if I take advantage of any of these benefits, is it going to impact me when I go to buy a home? These are great questions. And once again, there are a number of sources that you can utilize at your fingertips. One in particular, your bank, because they're the ones that are loaning you the money or managing your loan. These are definitely professionals that you want to reach out to and ask these specific questions of. And obviously, I do want to point out the very bottom of this PowerPoint slide that all of this information changes on a week-to-week basis. The CARES Act was passed, but things are still being fine-tuned. The federal government really isn't adding anything to the CARES Act, but they are fine-tuning the details of the CARES Act and being more specific as to who qualifies and who doesn't qualify for some of the benefits. And as we move forward throughout 2020, just once again, be patient, but also be understanding that there will be things that change throughout the year. Each bank or financial institution has been handling the loan applications differently. The state of California has tried to put together this PUA application process literally within the past month, with historic levels of people filing for unemployment. So once again, patience, we're going to get through this together, but utilize as many resources at your fingertips as possible for this information and any questions that you have. I did want to mention that in 2018, we had a new tax bill. A couple unique things are happening over the past 2 years, as well as coming up in November. We have an election coming up this year. So we're all going kind of through this turmoil, right? We have the pandemic, we have a new tax bill that's only 2 years old, and then we have an election this year as well. So make one thing a point to yourself that in 2018, the federal government for employees, they took away a lot of benefits, a lot of tax benefits for employees. In fact, most employees are only able to deduct mortgage interest, property taxes up to $10,000, and also charitable contributions. The state of California hasn't conformed to that yet. So when you go to file your tax returns, just understand that as an employee, you still want to gather as many deductions as possible and write them off on your California return. It might not make much of a difference on your federal tax return, but this is definitely something you still want to take advantage of. This tax season, we had a lot of questions about whether or not people should be bookkeeping for their expenses anymore because the government took those away on the federal side for employees. Well, of course, because California still allows for all of those write-offs. They still allow for entertainment deductions, which the federal government got rid of completely as a deduction. So even though it's limited to 50%, you still want to add up all of these deductions and really hone in and take advantage of all of those write-offs. Now, if you are thinking about starting a business or having a side business, because like I said, a lot of my employee clients are also starting small businesses and maybe running, especially because they're quarantined at home now, they're trying to figure out other ways to generate revenue. And if you figure out a way to generate revenue, or let's say you're married and your spouse has a business, there was a huge change to qualified business income in 2018 that actually made 20% of a company, of a self-employed company or a corporate company, an S Corp or a partnership, one major change made 20% of qualified business income tax-free. So some individuals saw major tax cuts in 2018 and 2019 because of this benefit. But remember that you have to have some sort of qualified business income to benefit from this. So if a spouse or if you yourself are operating as an employee or as a self-employed business, you want to make sure that you are qualifying for some of the major tax cuts that were introduced in 2018. And also how to navigate around some of the limitations you may have seen in 2018 and 2019 because of the new tax bill. One thing in particular for employees in the past where the federal government has limited some of your deductions, there was something under the old tax bill called alternative minimum tax. And for those of you, I'm not going to go into AMT right now because it'll take up another hour of your time. I don't want to do that. But AMT was a huge restriction for employees when they went to deduct things like property taxes and state income tax and DMV fees, and then all of their unreimbursed business expenses. Well, AMT kicked in at about $130,000 of income. Well, I mean, you could have two teachers making W-2 income, making over $130,000, $138,000 of income, and they were subject to AMT, meaning that they weren't allowed all of their deductions on their individual returns. So AMT has changed under the new tax bill. So in 2018, if in past years of 17 and before, if you were subject to something like alternative minimum tax, there may have been ways for your tax advisor to apply for refundable credits under the new tax bill to get you some of that benefit back. Because you've been limited for so long, the federal government changed to where you might actually be able to receive a refund for some of these AMT limitations in past years. So once again, I'm letting you know about this to, one, show you how confusing the tax code could be, but two, about how, why is it important to have a tax advisor to map out the road for you and to show you all of these benefits. It's not just me preparing taxes in an office. Sure, I prepare taxes, but a majority of what I do and what we do at Robert Hall & Associates is advising clients and leading them in a direction to where they can minimize liability, increase refunds, which is the same to me. If I minimize liability, I'm actually keeping more money in your pocket. If I increase refunds, still same thing, keeping money in your pocket through strategizing, through planning. So a major time of the year for us, aside from tax season, a really busy time of the year for us is year-end planning. So in October, November, and December, it's really important for you to reach out to your tax advisor and talk with them about some of the major changes that may impact you or your spouse, or maybe even a family member that you're concerned with, and maybe you help them out with taxes, how some of these changes are going to impact them. More importantly, if they are the individuals who are receiving some of the benefits from the CARES Act, How are they supposed to use that money? What does that mean for their tax situation next year when they go to file? How is this going to impact them? There will be a lot of questions this year, and just understand that we're here to help with any of those questions. So I did want to mention as I wrap up here, and we take questions in a little bit. Is there anything else that you should be doing? That's always a general question that we get as well. We've done all the planning. What next, right? Well, Robert Hall & Associates, we've been offering free consultations for a number of years. Obviously, if this was a live seminar where you were sitting in front of me, I'd hand you a free complimentary consultation card. But because we're doing this all digitally, we do offer our free consultations via text. So if I've hit a key point where you have a couple questions in regards to that, or specific questions that you don't really want to ask during today's webinar, you can text RHA to 38470. That automatically submits you or a family member or a friend or a coworker for a free 30-minute consultation. Obviously, right now they're by phone, but as soon as we open back up and we start seeing clients in person, feel free to come by and have that 30-minute consultation in our office. We do service tax filings in all 50 states, so there isn't a state that we cannot advise in or investments that we cannot advise on. So we've been around for quite some time, and we're here and available to help. So thanks again for having me today. I'm going to toss it back over to you and see if we want to do questions now or questions at the end.
Thanks, Tony. We do have some questions. One of the questions, I don't know if you see it under the Q&A, someone's asking for a phone number. If you want to give out your phone number.
Sure. Phone number is, I'm trying to get to the questions, because when I'm sharing my screen, it doesn't for some reason allow me to see the questions. So hang on one second.
Oh, do you want to end share screen then?
Sure.
There we go.
818-242-4888. And you can also check out our website, roberthalltaxes.com. Our website has some great information. Why did that not go through? Huh.
Oh, here we go. I can type it in. What is it?
It's 818-242-4888. Yeah, for some reason, the question completely dropped off of my my screen. I don't know why.
All right. Well, feel free to, still send questions through the Q&A. Tony can answer as I start talking about employment law, which is one of my favorite topics. That is what our firm is based on. And so I will share my screen and get started. So, just to give you a little bit of background on us, well, on me specifically, I started this firm, and, as a kid, my parents ran a printing company, and it was called Gap Printing. G was for Glenn, my dad's name, A was for Angie, my mom's name, and P was for printing. And over the years of them running this business, I got to go in and see what it was like to not only run a business, but to have employees. And over time, employees came up with one issue after another, and it really tore my parents apart. And unfortunately, I wasn't a lawyer at the time, but they ended in bankruptcy and divorce. But I knew early on that I wanted to be an employment lawyer to help protect and defend small and medium-sized businesses in California. And so in high school, I got a job at an employment law firm. I was there 8 years. I worked at 2 other firms after, going through law school, passing the bar, and then started my own practice. And I think that it's important to note that with COVID-19, we are going to see a rise in litigation cases in employment law over the next 6 to 12 months. So it's really important to do everything you can now to protect yourself and your business. With that being said, because I am a lawyer, I do have a disclaimer that content on this webinar should not be considered legal advice. It's for informational purposes only. Communications and participating in this webinar do not create an attorney-client relationship. So a couple things I wanted to talk about today, a little overview of the Paycheck Protection Loan Program, how to safely bring your workforce back, some new hires, and then working remotely. As the coronavirus outbreak continues to impact markets and industries in the United States and truly around the world, businesses are now confronting significant and unique challenges. Successful navigation of these challenges require thoughtful and comprehensive planning. And as Tony mentioned, the Coronavirus Aid, Relief, and Economic Securities Act, known as the CARES Act, amends numerous provisions of the federal tax law affecting both businesses and individuals. So just to kind of stick with the CARES Act and specifically the PPP portion of it, on March 25th, the Senate unanimously passed the CARES Act. It provides $2.2 trillion in stimulus to individuals and businesses. The House passed it 2 days later, and then, of course, President Trump signed it into law on March 27th. And this provides stimulus to individuals, businesses, and hospitals in response to economic impact caused by COVID-19, the pandemic that we are facing right now. And for today, we're just going to focus on the PPP loan program. So, it started off with $350 billion, and the covered period is from February 15th, 2020 through June 30th, 2020, and greatly expands SBA loan eligibility. The program allows businesses suffering due to the coronavirus outbreak to borrow money for a variety of qualified costs. And then, of course, a month later, on April 24th, 2020, the PPP program was funded with an additional $310 billion. So what constitutes a qualified cost? That's payroll costs, and payroll costs are really defined as wages, commissions, salary, or similar compensation to an employee, payment of a cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave that the business already had in place, mind you, allowance for dismissal or separation, payment for group health care benefits, including premiums, payment of any retirement benefits, and benefits of state or local taxes assessed on the compensation of employees. This excludes, though, compensation for your employees that make more than $100,000 a year. So if you have an employee making, let's say, $120,000 a year, you are capped out at $100,000 for the year. And this is based on gross pay. So the idea is that anything that is actually included on your employee's paycheck stub is included. Anything not included, like your federal quarterly taxes, that is not included under what's a qualified cost. And then there's also, mortgage interest obligations, rent, utilities, and then any interest on debt incurred before the covered period. So that's before February 15th. And so to go over eligibility, I'm sure we've all heard in the news, these big organizations such as the Lakers getting funding. We've heard Chick-fil-A get funding, all those things. There is a caveat with regard to a specific classification, but I'm just going to stick with, you're eligible for the loan if you're a small business that employs 500 or fewer, or if your business is in an industry that has an employee-based size through SBA that's higher than 500 employees. And that's where you see those certain companies getting funding when, may or may not should have, I don't know, I don't want to go there, but, that's what we're seeing. The CARES Act does not describe when the number of employees should be identified for the purposes of the SBA loan regulations, but you look at the average number of employees in a pay period over the immediately preceding 12 months. Now, there has been additional guidance since then of how to calculate your full-time equivalent employees, but it is based, just to note, that it's based on an employee who is working 30 hours per week. So anyone working 30 hours or more per week is considered a full-time employee. The business had to be operational as of February 15th, and then you need employees. So the loan is limited to either the box on the left or the box on the right. And so the box on the left says the sum of the average monthly payroll costs times 2.5 plus any disaster loan taken out after January 31st. That will be refinanced into the Paycheck Protection Loan, or $10 million. And again, the term payroll cost is defined specifically to include compensation of an individual employee, not to include, compensation of anyone making over $100,000. It's prorated. The amount is intended to cover 8 weeks of payroll expenses and additional amounts for making payment towards debt obligations. So, a common question I've been getting recently, a couple actually, and that I just want to address head on, is whether or not you're able to run maybe an extra set of payroll in order to get within that 8-week period. And as of right now, I do not see any guidance prohibiting that. And we are, and Tony, please, chime in and correct me if I'm wrong, but we are saying that it's okay to run an additional payroll in order to get within that 8-week covered period.
That is correct.
Yeah. And then another question we're getting to is if you can just go ahead and bonus everyone, under $100,000. And our recommendation is not to do that. I don't know, Tony, if you have some thoughts there as well.
It has to be consistent with the payroll that had been leading up to the time of the economic disaster. And just to make everybody aware of this, I read just a couple days ago, actually, I started thinking, okay, well, this is great that everybody's applying for these loans and qualifying for it, but what is the penalty for fraud on all of this, right? The penalty can be up to $1 million. For fraudulently applying for the loan, for using the loan or misusing the loans in different ways. So obviously that's for a much larger institution, the $1 million penalty, but just be aware that you have to make sure that you're utilizing the PPP money for something that is obviously part of the list of qualified expenditures, but it has to stay consistent with what you've been doing up to the date of the pandemic, and then also over the next 8 weeks. You can't just bonus out everybody the money. You have to keep the payroll consistent, and obviously for individuals making under $100,000.
Yes, absolutely. That is in line with my understanding as well. And so the loan has the ability to be forgiven on a tax-free basis. An eligible borrower of a covered loan guaranteed under the SBA is eligible for forgiveness of the SBA loan in amount equal to the following costs incurred and payments made during that covered period. So during that 8-week period, and that's your payroll costs, interest payments on covered mortgage payments, not towards principal. And mind you, another question we're getting is, oh, I'll just prepay my mortgage or my rent for the next few months. No, do not do that either. Please, you can do that definitely, but it will not be forgiven. So caveat there. Covered rent payments, covered utility payments. The covered period, of course, is that 8-week period beginning on the date that the loan started, the origination date on your SBA loan. So it's important to calculate this correctly. Either speak with Tony, your CPA, and also your banker. You want to have everybody on your team in line with maximize this loan forgiveness. But of course, remember, if you're not able to maximize this loan forgiveness, you still get this loan at a 1% or less interest rate, which is a phenomenal interest rate. So if you have the ability to do that, keep that in mind. So, and mind you, as Tony mentioned, the purpose of the Paycheck Protection Program is to help you retain your employees at their current base pay. If you keep all of your employees, the entirety of the loan should be forgiven. If you lay off employees, the forgiveness is reduced by the percent decrease in the number of employees. Now, there's a lot of calculators out there that you can use to kind of gauge, but I definitely recommend getting a professional opinion on this, such as through Tony, your CPA, your banker. And if your total payroll on workers making less than $100,000 annually decreases by more than 25%, loan forgiveness will be reduced by that same amount. You have to look at a number of things. One, of course, is the payroll costs. 2 is your employee headcount. And lastly, if anyone is going to make less than 25% of what they were previously making. These are all the factors that are going to weigh in on loan forgiveness. And if you've already laid somebody off, you can still be forgiven for the full amount of your payroll costs if you rehired your employees back by June 30th, 2020. And there's been some guidance that's come out recently that talks about when you go to rehire, it needs to be a good faith offer, and needs to be in writing. I mean, definitely put everything in writing, document everything. And it needs to be the amount that the employee was making prior. That's my understanding, Tony. Again, chime in here, but with the same number of hours worked as well.
Correct. That is correct. Right on.
Yeah. The purpose, of course, is to encourage employers to rehire any employees who have been laid off due to the COVID-19 crisis, and you won't be penalized there. So, yeah, the percentage of laid off employees will impact, as an employer, your ability to obtain loan forgiveness. Something just to keep in mind, it will be a problem for you if on June 30th you have employees on unemployment. So if you're headed in that direction, try to do something about it sooner rather than later. You can theoretically wait more towards June, but that will impact you. So that's kind of the easy way we're suggesting our clients to look at this. Okay, so to seek loan forgiveness, and every bank might be a little bit different, but a borrower must submit their application with documentation verifying the number of employees and pay rates, canceled checks showing the mortgage rate or utility payments. And then again, if you rehire by June 30th of this year, you will not be penalized. So as far as when you bring back the workforce, OSHA has come out with guidelines which identify several employee risk categories in order to assist us business owners in determining what safety precautions are necessary. I definitely recommend everyone go to OSHA.gov for guidance on this because it can be very complicated. Essentially, there are 3 risk categories. Your healthcare workers and healthcare support are considered high-risk categories. Employees with high-frequency contact with the general public, such as school staff, those working in high-volume retail, those working in high population density workplaces, those constitute the medium exposure risk group. And then employees with minimum occupational contact with the general public, such as your office employees, your remote workers, those constitute the lower exposure risk group. And once you know if you're in high, medium, or low, you can check on OSHA and they will give out specific guidance there for each of those categories. As you begin to bring your workforce back and determine the next steps, you want to pay attention to employees returning from affected areas, those in close contact with those returning from affected areas, those who've tested positive for COVID-19, and those showing signs and symptoms. And as we begin to bring our workforce back, it's probably not a matter of if someone is going to test positive for COVID-19, it's a matter of when. And if anyone wants it, I've put together a 3 or 4 page PDF. I'd be happy to email it to you on a COVID-19 response plan and the steps that you need to take as a business owner to minimize any liability there. So I'm happy to email anyone who's looking forward to that. So employees returning to affected areas, this isn't obviously as big of a concern with travel bans, but basically, they will be required to self-quarantine for 14 days. They may be required to undergo mandatory health screenings from federal, state, and local authorities. And then employers may require a medical release to return to work for these employees. And as they return to work, you may want to maintain that high level of alert. Those in close contact with individuals returning from affected areas, these individuals may be required to self-quarantine, and then as an employer, you can also require a medical release to return to work for these specific employees and maintain that high level of alert. If you have an employee who tests positive for COVID-19, immediately send them home or have them remain at home. Immediately treat the affected areas in which the employee worked. As per CDC, they have specific recommendations on what to do. You want to advise employees and or customers who were in contact with the affected employee and offer them reimbursement of medical testing for your employees. Something you don't want to do, though, is identify the employee by name. That information needs to be kept confidential and on an as-need-to-know basis for those employees. And also remember to file workers' compensation paperwork if applicable, and you might want to contact CDC and local health department. If you have employees who are showing signs or symptoms, you may send them home upon the observation of symptoms consistent with COVID-19. You may require a medical release for them to return to work as well. Immediately treat the affected area in which the employee worked per CDC. And again, you can advise employees and customers who are in contact with the affected employee that there's been no diagnosis, but you are acting in an abundance of caution. But again, do not identify the employee by name. So as you begin to bring the workforce back, in order to assess the risk, you may in fact ask your employees to inform you if they have come into contact with someone diagnosed with COVID. You can ask them to inform you if they have symptoms of the virus. You can ask, or of course, if they've been diagnosed themselves with COVID-19, or ask them to inform you of recent travel to highly affected areas. So what you may not do is to target an individual employee unless you have an objective basis for asking. Now, as businesses had to close rapidly, we had a number of clients who accidentally age discriminated against with their employees. They decided in order to protect their employees over the age of 60, they would send all of those employees home. Well, that is asking for an age discrimination lawsuit. You don't want to do that. You need to observe symptoms with an objective basis, and you don't want to ask about any other underlying medical condition or disability information. So we're to the point where we only represent the best business owners with good hearts, and they mean well, but they are, if you send your workforce home over the age of 60 or any certain age, you are asking to be sued. So keep that in mind. There are specific safety precautions with the CDC. Here is their website. Bottom line is to ensure that all frequently touched surfaces are clean and disinfected regularly throughout the day. And that means your tables, your doorknobs, your light switches, your countertops, your handles, your desks, your phones, your keyboards, all of those things, toilets, faucets, sinks that are frequently touched surfaces. Err on the side of precaution when assessing the risks. CDC has provided a risk assessment guide on their website. I strongly encourage you to look it up. Avoid conducting anything that could be considered a medical examination yourself. Now, a question we've been getting recently is what about taking the temperature of employees? And we still are not recommending it for our clients, but the EEOC has issued guidance that says it's okay for employers to take employees' temperatures. If you are concerned about a particular employee displaying symptoms of COVID-19, send them home, ask them to consult with a doctor, and receive a medical clearance to return to work. You can also have employees take their own temperature prior to walking in the door at work. That might be another way to resolve the issue. But if there is a question of whether or not COVID-19 was contracted in the workplace in the course of the employee's work, provide workers' compensation paperwork and leave it up to the carrier to decide. This is uncharted territory, and while typically there would not be liability, for example, by contracting a cold or flu at work, this is really an unprecedented situation, and there may be workers' compensation here. So, leave it up to the carrier to decide. With OSHA, OSHA's general duty clause requires employers to furnish to each worker employment and a place of employment that is free from recognized hazards that are causing or likely to cause death or serious physical harm. Employees may refuse to come to work only if they believe they are in imminent danger. And there's a specific definition with imminent danger to include any conditions or practices in any place of employment which are such that a danger exists that can reasonably be expected to cause death or serious physical harm immediately. I just talked through this with a client earlier today about whether, an employee can refuse. And the answer is no, unless there is an imminent danger. As if you're not able to bring in back your workforce, you may want to look at recruiting some new employees. I think with the unemployment rate going so high, it's going to turn from an employee-sided job market to an employer-sided job market. So just a couple quick tips here. Comply with anti-discrimination laws. Preserve an at-will relationship. In addition, you want to avoid references that would contradict an at-will relationship. California's labor code specifically says that an employment relationship with no specific duration is presumed to be employment at will, but there are things that you can do to not have it be an at-will relationship. So you want to just avoid any advertisements indicating that your organization is seeking a long-term employee, or even something that says looking for someone who can grow with the organization. And then with BFOQs, that is a bona fide occupational qualification, and that's a characteristic that employers are allowed to consider when making hiring decisions, even though in other contexts, these characteristics would be considered discriminatory. So for example, you have a religious school, they can require teachers be members of the school's religion, but religion would not be a bona fide occupational qualification if it's an office manager position in a dental office. One thing about criminal background checks, they're generally only permitted after a conditional job offer is made. And so any employer with 5 or more employees is absolutely prohibited from asking about criminal history on job applications. And this was known as ban the box. This came out a few years ago, but keep in mind that you shouldn't be doing criminal background checks or asking about potential candidates' criminal history information. There are a couple exemptions, such as a security company requires somebody to carry a gun on them in order to do their job. Well, that's an exemption. So, but in general, don't ask about it. With checking references, there's not specific law requiring that you check a candidate's references. Courts have held, though, that employers can be held liable for negligent hiring for certain acts of their employees if the employer knew or should have known. Reference checks are often part of the hiring process, but there are a couple things you want to look out for. You want to obtain that written authorization from the candidate, basically having them sign a waiver authorizing you to investigate all information submitted on the job application. Employment applications should include that basic waiver, allowing you to check past employment, personal references, and education. Obtain this, of course, before you contract references. When contracting references, you don't want to seek information about the salary history of the employee. And I'll talk more about that in a minute, but don't inquire about conviction and criminal history, of course. That's what we just went over. I'm not going to get too much into testing candidates, but you want to make sure that if you are going to test a candidate, that there's no way for this to be looked at as discriminatory in nature. It's permitted as long as the test is related to the job. So. Consistency, create a list of appropriate questions, stick to the list, don't vary, make sure it's consistent throughout if you have a number of people doing interviews. Also avoid overpromising, right? Oftentimes people will say, as long as you do a good job, you'll have a job. And that could be interpreted as an oral contract, and that may prevent you from laying off that employee during an economically necessary layoff, if they're in fact doing a good job. So avoid any of these types of questions: race, religion, national origin, all those things still you don't want to go to. One of the questions I'm getting right now is, are we allowed to require an employee to tell us if they are sick? So you are allowed to inquire and ask an employee if you have reason to believe they've been tested positive with COVID-19. If you don't think it's related, if they've broken their arm or something, then no, you're not required. But I would suggest putting up some signs about what to look for. Possibly that might help if you have some signs of, these are the current symptoms that are associated with COVID-19. We are asking all employees, in order to keep other employees safe, that they come to us if they're experiencing any of these symptoms. So I hope that helps. You know, you want to possibly reframe some questions. Are you a U.S. citizen is of course inappropriate, but if you are hired, can you verify eligibility to work in the United States? That would be an appropriate question. Instead of asking, do you own a car, ask, do you have transportation to get to work? Also, do not write notes on candidates' applications or resumes. An employer made a notation on an application for a candidate for a position at the jewelry counter of a large department store. While he intended the notation to mean no experience selling jewelry, he actually wrote no Jew, and that caused a candidate to file a religious discrimination lawsuit against the store. Quickly on working from home agreements, we would recommend having a written agreement. You can say in the agreement that it's only temporary, that it outlines the guidelines to work from home. You know, you can say that while the California stay-at-home order is in place, or just during the pandemic, or whatever short-term or long-term thing that you want to say with your staff. But you want to also lay out who is eligible to work from home, because of course not all jobs can be performed at off-site locations. It's also really important to lay out expectations with your staff if you have them working from home, their start time, their end time, being available and responsive throughout the day, still continuing to follow company procedure. One of the things that we see here is where I think a lot of companies are opening themselves up for employment lawsuits in the future is not keeping track of meal and rest periods for your employees working from home. I strongly recommend it. It doesn't have to be anything fancy. Fill out a standard Excel spreadsheet, clock in, clock out for breaks, clock in, clock out for lunch, have them turn it into you every Friday. Just something in writing that says that they are tracking and taking their meal and rest periods. Because I guarantee you in 6 to 12 months, you are going to see a rise in employment lawsuits from employees saying that they've never been able to take a meal period or rest period, that their schedules were just too busy, that you were asking for them to respond to emails at 11 o'clock at night, all those things. So in your employee handbooks, make sure you have a do not work off the clock policy and that you have the ability to track time worked. Also, reimbursable expenses. Please, please, please be reimbursing your employees for use of their internet and cell phone. There is case law that says that even if an employee already has a cell phone and is already paying their cell phone bill, a business cannot have a windfall by passing on operating expenses to the employee. Keep that in mind. Someone is asking rest breaks. We don't clock in and out usually. It's supposed to be paid time. Yeah, that's fine. Rest breaks are definitely paid time, but you still want to keep track of them. And I would highly, highly recommend that you keep track of your breaks. I cannot press this enough. Even though they're paid, it doesn't matter. Just keep track of them. And then, is it okay to ask applicants if they have COVID-19 or are at risk to having been exposed? So I guess it would depend on the situation. If you're interviewing candidates, first off, I want to say this. You don't want to do anything that can look like you are discriminating against someone who is sick. So if you are able to take an interview via Zoom or something along those lines, I don't think that it would be relevant to ask the person whether they have COVID-19. And it's pretty short-lived as well. I mean, for some people, I guess, I won't go there. But, you know, if you are requiring them to come in and have contact with other staff members, which could potentially put other staff at risk, then I think you have the ability to ask whether or not, you know, they've been exposed. So that's what I would say there. And you know, whoever your employment attorney is, I would strongly suggest you check in with them at least twice per year, and especially during this time, during this pandemic. As a matter of course, you know, minimum wage usually goes up in January and July of every year, so check in with them regularly. At least do a handbook review once a year. And I am happy to say that I am offering an addendum to your employee handbook. I will send it to anyone who wants it for free. It's just several pages, but it just talks about the pandemic and things to watch out for that you can just add as an addendum to your current employee handbook. So I'm happy to send that to anyone who wants it. Just email me. Make sure whoever you're using has an experienced team of attorneys behind them. All the attorneys at my office have 10 to 20 years of employment experience or legal experience. And then something we offer is an early liability assessment, right? That way you know what's at stake and whether or not it's worth it to proceed through litigation, or maybe a severance might make more sense. We have an employment compliance checklist as well. This is a couple things that you want to look for. And I'm happy to take any questions as we wrap up in the next 2 minutes. I know Tony's still here too. We have a text as well, HF Law to 66866 to receive this checklist and any other up-to-date news on any employment matters. I promise I don't spam you, but when the Department of Labor comes out with something, I want to make sure I get it in the hands of all of my clients and friends as quickly as possible. So you can get on our mailing list there. And then this is just my contact information if anyone is interested. So with that being said, I think, Tony, we got through all the questions, it looks like. Anyone I'm sure can email myself or Tony, and we'd be happy to answer anything that we can. Well, Tony, it's been a pleasure doing this with you today.
Thank you so much for having me. Thanks, everybody, for attending.